Hey, good morning, everyone. And well, actually, I apologize. Good afternoon, everyone. Let's get this started off on the right foot. And welcome to today's session of the Wednesday break, where we're going to be talking about some updated firearms regulations that have come out within the last looks like 9 months here. So today we have with me Courtney Agrusa, who's an attorney in our municipal law group, and also Cliff Hammond, who is an attorney in our employment law section. My name is Robert Hamor. I am your host today, and I am a corporate and real estate attorney with Foster Swift, representing companies from 10 employees all the way up to about 1,500 employees. So I also work with the Firearms Practice Group. So this is a area that is kind of near and dear to all of our hearts. So before we get into today's session, I do want to level set on a few items. So first of all, our conversation today, it's not political. We're not here to discuss whether we agree with the laws, whether we don't agree with the laws, whether they're good ideas, whether they're not good ideas, are there other alternatives? We're here to discuss the landscape of the laws right now, no matter which side of the political aisle you are. It's part of the compact that we have with the United States is that we are going to follow the laws, and having the information as to what is out there allows us to better analyze our own behavior and advocate no matter which side of the aisle you are on this admittedly political topic. So again, today's session is designed to just kind of give a primer as to what some of these new laws are, what some of the effects are, and what some of the issues that we're seeing on a fairly regular basis dealing with these laws. Please note that, as with many things out there, this is not legal advice, right? We're kind of giving overviews here, and particularized situations and the facts that result therefrom are really going to drive any analysis on some of these laws that frankly have some potential criminal consequences to it. So again, we encourage everyone to investigate these laws and make sure that they have a clear understanding, whether you are here as a gun owner, as a manufacturer, a municipality, someone advocating, on either side of the political spectrum. So today we really want to talk about three general areas that are out there. There is the new red flag laws, also known as the extreme risk protection order laws. There are some significant changes to the way that firearms are purchased, the paperwork associated with that. And then there's some significant changes with respect to the safe storage of firearms. And if we kind of aggregate all of the changes in the law, we can kind of get them into those three categories. And this conversation is again going to implicate municipalities, individuals, employers, and all of those certain areas that are out there. So I'd like to start off this conversation by talking about one of the most covered laws that are out there, the extreme risk protection orders, okay, or red flag laws as they're often called. So, and I know, Courtney, you're a municipal attorney. You deal with this on a fairly regular basis. I know it's near and dear to your heart, and I know that we fielded a lot of questions on these ERPO laws in the recent months as municipalities try to figure out how to implement their obligations under these ERPOs. So with that in mind, can we kind of start this conversation off by letting us know kind of what the ERPO law is, what is it intended to do, and just kind of a general overview before we get into the nitty-gritty here.
Yeah, so the ERPOs, like you said, those are the red flag laws. These are the hot issues that everybody's been talking about because basically they give petitioners, who can be anybody, even law enforcement, an opportunity to petition the court for an order to essentially seize or have a person turn in their firearms if there is a belief that there is an immediate risk of harm to themselves or others. There's a lot of different scenarios that a person has to outline in their summons and complaint to the court to get this order. And there's a lot of factors that the court has to consider before simply, rubber stamping the order and pushing it through. It's all going to be very fact specific or specific. So kind of like what you were saying before, there's so many different nuances to it. But really, it's just, it's a new methodology to give law enforcement and petitioners out there an opportunity to petition the court to, I guess, essentially take a threat away from somebody with a firearm.
Okay. So when we're dealing with these ERPOs, and again, I know we fielded a lot of calls regarding them, right? What are we kind of focusing on when a ERPO, may be issued? What's the analysis, or what are, some of the factual circumstances where people can, try to see, how to move forward on an ERPO?
So some of the factual analysis, like I said, very, very particular to the situation, but, let me think of the best way of putting this here, and I'll let Cliff jump into if he has any insight. But things that are considered is, the person's history, of use or attempted use, of firearms, if they've got a history of threatening use of physical force against another person, whether or not it involves a firearm, things that are considered, as if there's evidence if the respondent has like a serious mental health illness or emotional disturbance, right? That could make them a danger to potentially themselves or to others. I think that there's also an analysis of whether or not somebody has previously had a personal protection order taken out against them, if they've previously been convicted of a violent crime. So there's all those kinds of things that are considered, even like if they have like history of alcohol abuse and things like that. All of that is taken into the analysis of whether or not an ERPO order should be issued.
Yeah. So what I'm hearing you say is, let's assume for a second that law enforcement is pursuing it, right, as opposed to an individual pursuing it, right? Kind of an easy way to phrase this conversation here, right? Law enforcement needs to have some particularized facts, right? This isn't, I don't like this person, I can go ahead and file for an ERPO, right? If law enforcement is looking at trying to, get one of these orders issued, right, they need to be able to articulate to a judge, certain facts that would support it, right? Using, history, using, any motivation and things like that. Is that kind of a fair and accurate summary?
Absolutely. And one thing that I want to point out, because of what you just said, petitioners, anybody realistically can petition for an ERPO, right? Law enforcement, that's a new one. That's an area that we are still navigating. And we're really working with our municipal clients on how to fairly and accurately apply this law from a law enforcement standpoint, right? Because now they're on this end where they can themselves petition. So they can petition directly to the court, or they can even do an expedited petition, right? Which is through a phone call. So there's a couple of different things there for law enforcement that's unique to, say, a regular citizen who's filing or seeking an ERPO.
Yeah.
Rob, it's a good question, because from my standpoint, as in the employment world, a lot of times before the new law came out, the ERPO, what we would have is people would go out and get a PPO or try to get a restraining order against somebody from being in contact. Now, this is just that next level, right? So somebody's doing threats and things of that nature. And you would have a lot of times where people would threaten, hey, I'm going to shoot the place up, or I'm going to hurt somebody. And the company sometimes would be very afraid of what was going to happen based on that. They would assist the employee to go down and get a restraining order, get an emergency ex parte order. A lot of times the judges don't want to give it without an opportunity for a hearing. And so you can still go down, and I've helped out, individual employees and some companies try to get restraining orders. What this does is, I think what Courtney is saying exactly, they're looking for factors. Law enforcement's getting involved. What are the exceptional factors that we're going to have to take this exceptional remedy for? Because the law essentially is saying there are going to be times, if you can point to the facts, where we need to take a quick action as opposed to waiting through the process. And that's all this does. And it's no different, really, I think, a lot of these things from my perspective, than what we have in place already for protection orders that employers and other employees are used to. And the only difference is going to be it's a green law. So how much will judges? And I can tell you, go to certain courts, I can get an ex parte without the person ever showing up restraining order against somebody. Other places are going to say, well, I don't know about that. Let's have 2 or 3 problems where the person is really, really in danger before we're going to give it to you. So depending on where you're located, who the judge is that hears it that day, you don't know whether the facts are going to be sufficient or whether it's going to take time. So I think there's a lot of area for us to grow, but there's also some area of humans getting involved with this too.
Yeah, as with most things, it sounds like it's another tool in the toolbox, right? You know, where you may have a scenario where, you know, we don't necessarily meet the requirements for a personal protection order that says this person can't be within 500 feet, right? But there may be, you know, sufficient, you know, evidence to be able to at least restrain the use or access to firearms, or vice versa, right? I'm not saying which one is easier or more difficult to get. Because as you say, I mean, I think it depends on what court you're in. It depends on what area, what judge you drew, right, is going to have an impact on that. So, you know, these ERPO orders, I mean, obviously they're incredibly political. We all know that that's is a big issue, you know, on both sides of the aisle, as whether or not these orders are good things or bad things, right? But at the end of the day, you know, it is the law in Michigan and it's out there, right? So, Courtney, can you tell me a little bit about, you know, if an ERP order is issued, right? What needs to be included in those ERPOs? And then the second question I'm going to ask that I'd like you to touch on is, you know, what should municipalities do in order to kind of, you know, prepare and set policies, you know, in order to implement for these ERPOs? Because look, the history, there is none, right? This is a brand new law. We don't have 500 years of jurisprudence saying this is what you should and should not do. And Cliff, I share that with you as well as with employers, because, you know, employers may have certain policies that need to be discussed on that.
Yeah. So
Courtney,
that's
why
really.
don't you start?
Oh, go ahead, Cliff. Sorry.
No, Courtney, go ahead. I think you got the bulk of this one, then I'll finish up.
Okay, so when it comes to issuing the order, you know, again, very fact specific, because there are scenarios where the judge might say, you know, you've got to relinquish your firearms within 24 hours, or there might be language that says you've got to relinquish it right away, right? So that's going to be one of the things that's included in the order, as well as if there's a need for a search warrant to be executed by local law enforcement to make sure that all the firearms have been removed from a person's home. Whether there's a restraining capacity to that order, a description of the firearms, if they're known or unknown, that's a big key element as well, because it's not necessarily likely that you're going to know every single firearm that this person has access to. They're going to designate the local law enforcement officer who's in charge of enforcing the order and just things of that nature, right? And there's also going to be details about the appeal process. I want to emphasize that, because I think there's this misconception out there that once an ERP order is in place, that there's no rights for the respondent, right? That their firearms are just gone. But in actuality, the statute does account for appeal rights for those individuals. And those are pretty detailed and laid out very clearly in the statute.
Yeah, and I think that that's, again, consistent with what we've seen in the past with restraining orders. And what we want to do is make sure that people don't feel like they have no recourse. Somebody goes in, they say whatever their side of the story is, and that's it, you're done with. That's not how it works now with, you know, temporary restraining order or a PPO. You can go in and try to get a judge to agree that there are facts of warranty, you know, an emergency situation, and a right to go in there and say, no, you only heard half the story, and try to get that back. From an employment side, what I look at here is this really doesn't change much from an employer's side of the view, because what you're trying to do is you have a general duty to keep your workplace safe. And now there's another potential tool, but frankly, you're not going to probably run out and get one of these as an employer. Your employees might, but most likely law enforcement's the one you're going to get involved to try to go down this process and involve them. And that's what I think Courtney's adding to this, but it's another tool that we can utilize, that people can have, whether you agree or don't agree, the process is there. And so we just need to know that it's involved with our situation. Again, the judges make the decisions here, right? Yeah. So what we can't do is tell you the judge will or won't give this particular remedy. That's one of the interesting things about this law. It's new law. We're going to see how judges handle it. Maybe their views of how this should be done or whether they agree with it might take, you know, an impact on how they do it in the beginning of how this is implemented. But ultimately, there's going to be a process that's going to be set forward, and we're going to know exactly what it is each judge is looking for more closely. But again, from a general standpoint, from an employer, you're looking to protect your business, and your business protections are already there against somebody who has a gun or doesn't have a gun. Let's just say there's an order. okay, you got an order. Now you still got to make sure your workplace is safe because maybe they
Yeah.
say turn your gun in.
Yeah, an order is just a piece of paper. It's like a
Yeah,
judgment,
it's a piece of
right?
paper, right? And so it's another piece of paper, and we don't want that person to break that, but it's another opportunity to go above and beyond for, our employee protection and for, the company's protection.
Sure. And look, we can spend hours talking about these ERPOs, right? We've got 30 minutes here to kind of give an overview, of these three laws here. But let's admit, these types of analyses and conversations really do require a lot more, time and discussion. So that may be something that's a focus, for subsequent or separate sessions moving forward. So I'd like to talk a little bit about the next law that we have coming up here, which is the safe storage law, right? And this is a new law that's out there that there's some misconceptions on as far as the scope and the breadth of the law and what needs to be done. So I'd like to start off the conversation by just, explaining what this law is, and then we can kind of talk about, the implementation of it, right? So under the safe storage law, a person has an affirmative duty, on their property or the property of another, right? It's not just limited to their homes, right? To take certain action to secure a firearm if there are minors present or there's likely to be minors present in those areas, right? So again, some people think it's a, oh, I don't have kids at home, but my nieces and nephew come over, every other day. It's not, it's not something that applies to me, or this just applies to my property, right? So again, there's certain misconceptions out there, and under this law, the person has an affirmative obligation to store the firearm in a locked container like a safe, keeping it unloaded and locked with a locking device, like one of those trigger locks or the combination locks that actually by law come with almost every single firearm out there, right? And then if you're entering into a property, right, and you need to store that firearm, locking it in a vehicle, locking in a some sort of lockbox, right? And the intent of this law, right? And again, not to get on the political side, but the intent of the law as published with the law was to, hopefully restrict access to firearms by minors, right? It's the unfortunate thing that we often, I shouldn't say often, but we sometimes see is, a child, gets access to a loaded firearm, that's kept in a drawer, and not knowing what it is, or just child curiosity or whatever justification you have, someone gets hurt or worse, right? So proactive, law that requires that securing of a firearm. And if a person, violates this law, there can be separate charges brought against that person, right? Now, we've seen in the case of the Crumblies, right? This is not the only avenue that a prosecutor has, right? Depending on the facts and circumstances that are there. But it certainly does open up certain avenues for criminal redress against people that may not have some of those aggregating factors, like I knew that my child was a threat to a person, I ignored it, or some of those other things that we sometimes see in these parental charging cases, right? So again, this is really one of those laws. If a child gets access to your firearm and it wasn't locked, you can be charged even if there's no aggregating circumstances out there. So I'd like to discuss the impact of that, both from the municipal side and the enforcement side, as well as the employer side, right? Because we think of the employer side as there's kids aren't often there, right? But there's a lot of businesses where there are children there, and if someone does decide to have a firearm on site, and that's allowable and it's secured somewhere, right? What their obligations are as an employer, right? And let's start off with that question, Cliff, with you, and then I'd like to get into the municipal side after that, Cliff.
Yeah, I mean, look, from a 30,000-foot view, if you have a no firearm policy in place, you can't have it there. There are some rules that we have to take care of. I don't want to get too detailed in that. I want to kind of focus on this, but if you think about it, let's just say you have a bus stop outside of your business, or you have children that are walking through, they get a hold of a car while they're walking. It's a pretty nice looking car, and they happen to hit a handle that's unlocked, and they go in there and they find a nice, firearm, get out there and start shooting around. That could be a problem for not just the person who has that vehicle and didn't store and lock that under this law, but now you all of a sudden say, okay, did you have a policy? Did you actually have a policy in place that made sense, that protected? So it's on your property. You have people that come in with vehicles. And if you don't have this, I don't believe the statute as drafted is going to encompass you as the owner, right? As it's drafted. But again, this is a green law, which means it's a new law. And so we haven't had it interpreted. So would somebody want to prosecute not just the individual, but you for having lax policies and not making sure you had it? Now, if you have a policy, now I don't think it's reasonable to say you have to go out and check the locks on everybody's door and tell them all they got to do it. But if you have nothing, there could be some vicarious liability there. But more importantly, if I get shot accidentally, I'm going to look for everybody. And if I have the child and the child doesn't have any money, obviously, and the parents might be broke, well, who's got more money? Well, we're going to try to chase down. So then we're going to say it's against the public policy. Yeah. Usually, if an employee gets hurt at work, it's workers' comp is generally going to cover it. But if a third party walking down the street gets shot by that, now you've got another injury you're going to have to deal with, which you don't have the protections of workers' comp. If an employee gets hurt, you're going to hope that you can go ahead and say, well, that's actually a work comp. It's on work property. It's in the parking lot. It's a mistake. But again, if you don't have a policy, the question is going to be, was the type of action you took by not having a secure policy to ensure these weapons were not in compliance with Michigan law, by just putting out a 2-page or a 2-paragraph policy, was that so inappropriate that you should be held liable for the injury to the coworker, whatever their issues are? So we have to take a look at those concepts and say, what do we want to do? And how far do we want to push our weapons policies?
Yeah. And what I'm hearing you say is kind of what I take from this law, right? Employers still have the ability to decide if they want to have a pro or an anti-firearm policy. Right?
Absolutely.
I've seen both sides of the coin, right? One policy says, no one can have any sort of weapon, on the company grounds. Other policy says, if you are going to carry a firearm, judicious use of marksmanship is appreciated, right? Correct. So again, you have it on either side, right? And we're not here to discuss the merits of either policy, right? Or what's pro and what's con on having either policy. But what I'm seeing is that nothing in this law really changes that, right? And I think that's a fair and accurate. Now, where I do say that there is probably a little bit of a change here, right? Is again, if you have let's say you have a permissive policy, right? And, for some reason, a person comes in with a firearm and, let's say it's in their purse, or, they take it off their body and they store it in a drawer or something like that, right? If a child gets access to that, right? Let's say you're at a daycare, right? And again, we can debate the merits of whether or not you should have a firearm at a daycare, right? Later on, right? Again, there's pros and cons on either side of that, right? But if you decide to do that, right, and take it off your body and store it somewhere, if it's not stored securely, right, you may have some liability there, right? That wasn't necessarily, as easy to present by a prosecutor before, right? Again, this isn't just your home. It's if you're on a property of another. And I think that bears discussion here, right?
I think that's a good point, Rob, because this is exactly what we talked about earlier. It's another tool, but instead of being a tool for somebody to help themselves, it's a tool for somebody in litigation to attack somebody for liability. So, it just gives another opportunity for exposure. That's what you have to reevaluate every time you make your policy decisions. No, there's good and bad reasons for you to do what you're going to do, but there's always a potential downside or a potential risk that's a business risk. And that's what this is.
And look, there's some uncertainty in the law, and we only have a few more minutes to talk about one more law that's out there. So again, a lot of stuff to go through in a very short period of time, right? I know that there are some unique questions that are out there as to whether or not, employers can prohibit, someone that, let's say, has a concealed pistol license from, carrying in their workplace while they're, engaging in the course of their employment with that employer, and, what that means and what it doesn't mean. And again, I know that discussion could take hours, right? So what I guess the takeaway of this law is, right, is as a firearm owner, right, you have that affirmative duty if you are going to store your firearm to make sure that it is stored in compliance with the law if there are children present or if there's likely to be. And again, whether it's at your property or another's property, that's the essence of that law. Gone are the days that you can have a peg wall with all your firearms in the living room when there's kids around, right? I mean, you can do it, but you have potential liability if something happens there. So again, I think people need to rethink, and there's some discussions as to what is a secured container, right? Is a glass display case a secured container, right? Is a 500-pound bank safe a secured container, right? Courtney, I see you shaking your head, right?
Well, I was going to say, I'm like, we all know that a glass display case is not a container, or not a fair way of restraining your firearms and restoring your firearms.
And there's certain things that are provided in that statute. So the last thing, because again, we only have a few more minutes, the last thing that I do want to touch on is the change to the purchase permit rules and how firearms are transferred, because I know that is a fairly large change here, right? It's administrative, but it's something that people need to be aware of, because the process for a purchase permit prior to this law, right, was for the most part limited to pistols, and the onus was on the buyer in order to file said paperwork, right? And let's start off with the analysis of where we're at, right? When a pistol purchase permit is submitted to law enforcement, right, that goes into a database, right? And there's a database that says this person has this firearm, right? When a buyer turns it in, right, that's when it's updated, right, under the old law. And if a buyer doesn't turn it in, then the state doesn't know who owns that firearm, right? All it has is the last known record, right? And look, there are certain civil and criminal potential penalties associated with not turning it in within a certain period of time. But again, stuff happens, right? Things get lost. You almost every municipality that I've been to has a drop box for these things. Whether it falls on the floor while it's being transported from A to B, all become problems, right? So I do know that this law fundamentally changed that process from a buyer side process to a seller side process, right? The seller is now the one who basically prompts that paperwork. And certainly, an argument can be made that the seller has a bigger incentive, of making sure that pistol sales record is accurate, saying, hey, as of this day, I no longer have this firearm in my possession, right? So, Courtney, can you talk just very briefly about this new law, and then also, what would qualify a person to receive a purchase permit, and conversely, what would allow a municipality to deny that permit?
Yeah, so I think you hit the nail on the head with the fact that, prior to the amendments that went into effect in February, local police officers or and county sheriffs and what have you were only focused on issuing purchase permits for pistols. Now it's firearms, right? And it's their job to go through the application and determine whether or not these individuals are qualified. So assuming that there isn't probable cause to deny an application, a person is qualified if they are, 18 years of age or older, a US citizen, they haven't been judged incapacitated, there's no pending criminal charges or felony charges against them, things like that. They don't have any orders against them, including ERP orders, right? So all those things are reviewed as part of the application process to determine qualification. Going back to like the probable cause, whether or not probable cause exists, basically what the statute says is that a purchase permit must be issued unless probable cause exists, leaving the person who's issuing the permit to believe that the applicant is a threat to themselves or others, or is likely to violate a local, state, or federal law. I'll give you a scenario that I think actually you and I addressed recently for one of our municipal clients, where they received an application, and while the person was filling out the application, the law enforcement officer observed that the individual had issues gripping the pen that they were filling the application out with, right? They lacked grip strength. I wasn't there, but so I'm basing this off of the facts that were told to me. So they lacked the grip strength. That gave the law enforcement officer pause to approve this permit, because they said, well, how is this person going to safely hold and shoot a firearm, you know, if and when they decide to go out shooting? That is not what probable cause is for purposes of this statute. And we advise them appropriately that had they denied that application based off of that personal belief, it was very likely that they would have been dinged with an ADA or Michigan Department of Civil Rights complaint charge, because it doesn't fall into the considerations outlined by the statute. So probable cause, you really got to look into whether or not the person is going to be a threat to themselves or others, and whether there's a strong likelihood that they're going to violate a local or state or federal law.
Yeah.
So.
Yeah, again, very, very particularized circumstances that revolve around that probable cause. And again, you know, it's a specific and articulable, you know, belief in A, B, and C, right? Whether or not you hit these particularized thresholds. So I know that we've gotten a lot of calls on that, you know, recently. And again, I think that, you know, especially municipalities that are issuing these, right? Sheriff's office, police offices, things like that, really do need to reevaluate their policies to make sure that they are compliant with these new laws, rules, and regulations that are out there. So everyone, it's 12:32. You know, I know we ran a little bit over on this. As I said, this is a lot of information to cover in 30 minutes. You know, I've lectured for 4 hours on ERPOs before, and even then I didn't have enough time to get it done. So, and that was just one of our topics here. So again, we wanted to bring to everyone's attention these laws that are out there. There is still a little bit of question as to, you know, what everyone is required to do under some of these laws, because they are green laws, as Cliff uses the phrase, right? There's new, we don't have, you know, 50 years of jurisprudence giving us guidance here. So again, knowing what your obligations are, knowing what at least the text of the law and, you know, and frankly, the spirit of the law, right? Whether you agree with it or not, right? Is important to determining your behavior moving forward. You know, whether you are a firearms owner, a manufacturer, a retailer, you know, a municipality, or you know, someone else, an advocate on either side of the political fence. So again, I do want to thank everyone for attending today. You know, the Firearms Practice Group is new within Foster Swift. We are populating a lot of information moving forward. So if this is a topic of interest, we would encourage you to visit our website, you know, sign up for our newsletters as things move forward, because we are going to be giving you some ongoing information, some ongoing guidance that's there. And again, whether you are a manufacturer, a retailer, a municipality, a gun owner, or an advocate on either side, if you do have any questions regarding these laws, you can certainly reach out to us to discuss them. So I would invite everyone to get on their calendars. October 9th is our next Wednesday coffee break session, and we're going to be discussing cybersecurity, what businesses can do. It is certainly an area where there is a lot of concern right now. Unfortunately, there's a lot of unscrupulous people that are out there. My mother's suffering from one of those hacks very recently, and I know, you know, the amount of time it takes to have to deal with that. So again, understanding what businesses can do relative to cybersecurity and some of the new rules and regulations, especially if you're a chief technological officer, and your certifications, will be a topic for our next Wednesday session. So again, I'd like to thank everyone for attending here, and have a fantastic rest of your week. Take care.